in Facebook or in Instagram, sometimes you will see that what happens is that some reels or some videos of the virtual high court proceedings are getting viral.
While the court proceeding at Bangalore is going on, some pictures came out which was not the outcome of that virtual court systems. So amongst the judges, honorable judges of respective high courts and also the honorable judges of the Supreme Court, they have come to the conclusion that the way we have make it easier, we shall put a cap on that. I have write down an article, use of technology for speedy delivery of justice. And that article cover around 6 pages. If I correctly remember, in 2008, that seminar was there. That book is also there with me. By that time, Honorable Chief Justice was Justice KG Balakrishnan, and our Madam President, Sri Pratibha Devi Singh Patil was the president, and our subsequent president, Mr. Pranab Mukherjee, who got the Bharat Ratna award, he was also there in that seminar. By staying in Orissa also, I have addressed some of the courts in Lucknow bench of the Allahabad High Court, in Bombay High Court. So this judicial appointment are becoming nowadays quite transparent. But in many occasions, it has been seen that some advocate, even though they don't have the good practice in bar, but because of their impartiality and because of their cleanness, because of their family background, they have been also selected.
Hello sir, welcome to the show. कैसा लग रहा है आपको?
I am feeling extremely happy that you have.
It's our pleasure, sir. It's our pleasure. So basically, you have been into legal services. So I want to know about your career, like how it started and how did you came up to this? Like currently you are representing Government of Odisha. Then how it came to this?
Started the practice at Bhubaneswar Court and Orissa High Court. And in the year 1996, I came to know that one Bar Council of India scholarship program, their Bar Council of India trust is doing that. Yeah. So I feel that all right, let us apply. And applied, we went also for the interview. It was done in the building of Orissa State Bar Council. By that time, the chairman, if I correctly remember, was Mr. Durga Charan Patnaik, uh, Senior Advocate of Orissa High Court, and uh, representative from the Bar Council of India were there. The representative from the Bar Council of India in that selection process was Mr. O.P. Sharma. He was the chairman Bar Council of India in the year 1996. And our own High Court, Orissa High Court, Senior Advocate Mr. Jagannath Patnaik, he was also representing to the Bar Council of India from the state of Orissa. And in the selection process, the secretary, Mr. Tandon,
Hmm.
Bar Council of India secretary, Mr. Tandon was there. So that was the selection process. Around many advocate friends who have participated, but fortunately, I have been selected by the selection panel, and by that time, there is a letter came to me that you have to participate in a seminar at Dr. B.R. Ambedkar Government Law College, Pondicherry. If I correctly remember the date was from 12th August to 16th August 1996.
Okay.
And as a fellow Bar Council of India from the state of Orissa, I was there along with our London Senior Counsel, Mr. Jagannath Patnaik was there. And presently, one of my who is very good counsel, designated Senior Advocate, Mr. Prafulla Ratha, he was also there in that Bar Council of India conference at Pondicherry in the year 1996.
Okay.
So, as a fellow Bar Council of India, during the then period, we have traveled across many international, participated in many national and national seminars.
Okay.
And in the process, acquainted with the different branches of like this career started.
So I have two, three questions regarding what you have spoke just now. First, I want to know what is Bar Council of India?
Bar Council of India, it is a body constituted at the national level. From each state bar council, each state having the state bar councils. In many occasions, there are two states but together they have the bar councils also. Just like bar council of Maharashtra, that bar council of Maharashtra consisting of Goa and Maharashtra.
Okay.
That's coverage the area of Daman, Diu, Dadra and Nagar, Haveli, Silvas, some of the portions, even out of Maharashtra also.
I think that the state is small. Goa is a small state. Pondicherry and all, they are very, Daman and Diu
Yeah,
are very small states. That's why they constitute and create a single bar council.
yeah. Just
Okay.
like in Northeast state also,
Mhm.
there are during the then time. Nowadays, bar councils are there. During the then time, I'm talking of around 30 years back. There was only one bar council, that is the bar council of Assam
Assam.
at Guwahati. All the representative they were coming from different all those seven sisterly states. So in many states, in many occasions, there are many states having the one bar council. Like in Orissa, there is one bar council. In Andhra, nowadays the situation is different. Earlier, it was bar council of Andhra at Hyderabad.
Okay.
After the separation states, the jurisdiction has been changed. So from each state bar council, one of the learned advocate friend uh, out of members, that will be selection process. The friend, advocate friend, those who secured the highest vote, they will represent to the Bar Council of India. And presently, the Bar Council of India is functioning at Rouse Avenue, institutional area, New Delhi. Although demand has been done by the present Bar Council chairman, Mr. Manan Misra, that there should be uh, uh, facilities for having a separate office in the campus of Supreme Court
Mhm.
of India, but that has not been till date materialized. So it is functioning at Rouse Avenue in institutional area, that is New Delhi 21.
Do every lawyers needs to be registered with the Bar Council of India or needs to be a member of Council of India?
During our days, particularly I'm talking of year 93, 94, when we enrolled as an advocate of Orissa State Bar Council, uh, uh, there was no interview. It is only by seeing the certificate, loss pass out certificate, and graduation certificate, plus two certificate, or intermediate certificate, and matriculation certificate. There was a scrutiny of the certificate, and after some months, they call us to the bar to get the enrollment
Okay.
number. And after getting that enrollment number, the law students, after getting the enrollment number, they are entitled to have the practice across India,
Okay.
including the Supreme Court of India. One advocate who enrolled, suppose in Maharashtra in Bombay Bar, or an advocate who enrolled at Cochin
Mhm.
from uh, Kerala Bar. Everybody can have the practice everywhere, irrespective of the jurisdiction across
Okay.
India.
So I wanted to know, there are two, three words that we have heard. Like there is a lawyer, there is an advocate, and there is a arguing counsel. Are these three same or there is some difference between?
So many advocate friends, those who are representing to the states
Mhm.
in the concerned High Court or at the Supreme Court level, there are different designations like standing counsel, additional government advocate. Thereafter, the respective states having their respective advocate general. Uh,
Mhm.
it is under the respective states advocate general, the entire state councils are there. So suppose Orissa state having this hierarchy, in some cases, additional advocate general being appointed in some states, additional advocate general.
Okay.
Some states are there, but that system not practiced in all states. Suppose uh, uh, this High Court of Himachal,
Mhm.
they have their additional advocate general and advocate general. But in Orissa, it is only the advocate general, and the next hierarchy is government advocate, and
Okay.
next to that additional government advocate. There are standing council and additional standing councils like this. So these are the advocate friends. Those are representing to the state. And advocate means those who get enrollment at the bar. Actually, enrollment given by the bar council.
Hmm.
In Delhi, the enrollment given by the Delhi Bar Council. And the Delhi Bar Council advocate, or the advocate from Tamil Nadu, or the advocate friend from Guwahati, or the advocate from friend from Rajasthan, they can have their practice in their respective state as advocate. But while they are representing to the state, they may represent in different name like this: additional standing council. But in national level, if we'll see, suppose we'll see in the Supreme Court, just like the Advocate General is the top post in the states
Hmm.
across India, at Supreme Court level, the advocate, those who represent to the country, the designation is Attorney General for
Got
India, for India, and thereafter Solicitor General of India. The difference between for and of is that Attorney General for India can represent India at different legal jurisdiction. So that's Attorney General for India.
Okay.
That's the designation, and Solicitor General of India. Thereafter, the additional Solicitor General and other hierarchies there at the Supreme Court level. So that's the little bit of difference in between this council and what you are talking of advocate. These are the little of difference.
While we were going through the articles regarding your interview, we figured out that there has been some serious allegations on judiciary regarding nepotism and transparency. If you see currently, there are 35 judges, I guess, in the Supreme Court of India. And it is often said that if you are a second generation judge, then you are most likely to be a Chief Justice of India in the coming years. Is there any discrepancy, or what do you feel about the transparency of judiciary, entire judicial system?
You see, so far as this allegation part is concerned, it is a very sensitive issue altogether. But after the third judge case, the system has become quite transparent. Uh, of course, in many occasions, it is happening so. Is son of a senior most judge or the Chief Justices of India, or a Chief Justice of different high courts, they are also representing as a member of the bench, as a judge of the respective honorable high courts. So it happened. Uh, there are maybe some minor incident, but overall, if we'll see, the appointment practice has become quite transparent. Supposed to say, there are many judges whose subsequent generations are also appointed as the uh, judge of the High Court and subsequent the Chief Justices of the Supreme Court. For example, recent Honorable Chief Justice Dr. D.Y. Chandrachud. He's a deserving candidate. He's a student of law at University of Harvard University. He completed his doctorate in jury. Thereafter, his practice at Supreme Court and also in Bombay High Court. So, in that case, there are some deserving candidates, those who are there, even if they are the son and daughters of the honorable judges. But many of them, they are quite efficient, and they have been appointed as judge at a early age of around 45, like that. So the honorable judges, those who have been appointed at the early age of 45 within, so that they can represent to the honorable Supreme Court of India in many occasions that is happening. So this judicial appointment are becoming nowadays quite transparent. But in many occasions, it has been seen that some advocate, even though they don't have the good practice in bar, but because of their impartiality and because of their cleanness because of their family background, they have been also selected as a judge of the Honorable High Courts.
Okay.
In the process, when one of the judge appointed without having much experience or without having much practice, that is happening in some cases. Instances are there. But after joining to the bench, in India particularly, the judges are quite laborious. By sitting in the bench, they get experience by hearing the many senior advocates, and by when there is a kind of interexchange of argument between advocates and honorable judges. So the inexperienced and without having much experience, those who became the judge, they also up to date themselves in days of their joining as a member of the bench. So particularly in India, I have my experience that even if somebody without having much experience, subsequently they have become the talented judge and retired as such also. And in their after retirement life, they are also quite helpful for the legal work in India is concerned.
So you have been a tech savvy. Like I see you have 6, 7 mobile phones. You are always on that and looking after the cases. And you had also written an article regarding use of technology uh, to clear out the cases and how technology can help to fasten the process in judiciary. Currently, we have more than 4 crore cases pending across different courts in India. So, what is your opinion on how this technology can help us to get rid of these cases as soon as possible?
Use of technology is a very good sign in the justice delivery system. It help to speedy disposal of the cases. Actually, in 1996, the seminar what was we have joined at Bar Council of India at Pondicherry. That is the seminar that topic was legal profession in
21st
21st
century.
century. And who are the participant there? As the faculty, many top teachers were there, like Professor Upendra Bakshi was there, Professor N.R. Madhav Menon was there, who is the founding father of NLU Bangalore. Then Professor N.L. Mitra was there, Professor Randhir Singh was there, who was the founding father of Nalsar at Hyderabad. And amongst many senior advocates, I am remembering the two, there are many senior advocates. In that seminar, Mr. Fali Nariman was there, passed away recently, not a senior advocate from Supreme Court of India. Mr. Soli Soravji was there, and Mr. Our best criminal lawyer of the country, Mr. Ram Jetmalani was there, and the present Attorney General for India, Mr. R. Venkat Ramani, and he happens to be the senior advocates in 1996. And because Mr. R. Venkat Ramani designated as senior advocate, and he belongs to Pondicherry,
Okay.
and this seminar is going to be held at Pondicherry. So our present Attorney General, Mr. R. Venkatramani, was also a faculty there in that interactive sessions, and Mr. Raju Ramchandran, learned senior counsel, the best criminal lawyer right now, uh, uh, who was representing Ajmal Kasaba as amicus in the Supreme Court of India. The best criminal lawyer, all those senior advocates were there, then professors were there, and we selected fellow of the Bar Council of India were there, and other members were there. In that seminar, legal profession in 21st century, what would be the practice procedure in 21st century? Way back in 96, almost 30 years back, that was the point of discussion. And thanks to the Bar Council of India chairman, then Mr. O.P. Sharma and others, they have think of that in after 20, 30 years, there would be a revolutionary change in the process of and practice of legal profession in the country. And subsequently, at different seminars, there was a seminar by International Law Association, whose head office is at London. And that seminar being organized by our Mr. P.H. Parekh, the Learned Senior Counsel, who is practiced in Supreme Court of India. He has organized that program in Vigyan Bhavan in 2002. In that program, it has been also witnessed those many foreign delegates were there. They all have given their opinion that technologies should be adopted in the legal profession in India, because they have adopted their technologies in USA, in European courts. They have adopted their technologies, and India was quite lag behind. So they have advocated for use of technology in the justice delivery system of India. And fortunately, in 2008, Konrad Adenauer Foundation, that is being one foundation in Europe, and they organized a seminar in Vigyan Bhavan in 2008. That is also being organized by Mr. P.H. Parekh, the London Senior Advocate, and many senior advocates were there, but that is being organized by Mr. P.H. Parekh. In that seminar, I have write down an article, use of technology for speedy delivery of justice. And that article cover around 6 pages. If I correctly remember, in 2008, that seminar was there. That book is also there with me. By that time, Honorable Chief Justice was Justice K.G. Balkrishnan, and our Madam President, Mr. Pratibha Devi Singh Patil was the president. And our subsequent president, Mr. Pranab Mukherjee, who got the Bharat Ratna award, he was also there in that seminar. And the then Prime Minister, Dr. Manmohan Singh, was also participated in the seminar amongst legal luminaries across world, across countries. They are participated, and they all come to the conclusion that there should be use of technology in the justice delivery system in India. But from that date till 2020 March, the use of technology was very in a running in a very slow pace. But all and sudden, on 23rd March 2020, when India declared this isolation instruction
Due to
because of
COVID.
this COVID, Honorable Supreme Court for the first time, Honorable Supreme Court immediately, not for the first time, adopted this virtual court system. Otherwise, it would be very difficult for across Indian people. They will suffer for their rights. Sometimes their civil liberties are has been curtailed. In that occasion, because there was mobility has been stopped, train, bus, air, so all means of conveyance has been stopped. So it is thanks to the then Chief Justice and Honorable Judges of the Supreme Court of India, they immediately adopt this virtual court technologies, and also instruct across all over High Court that immediately follow the virtual court system. And thereafter, after just few months, Orissa High Court, our Chief Justice was in Orissa High Court was Dr. Murlidhar. He is a very fast rank judge, and he first introduced this virtual court system in Orissa, and almost all the honorable courts could run on virtual court system. By that time, we advocates were not so much of acquaintance with this virtual court system. Many of the advocate friends even don't have the mobile set, which can through which can access or computer or laptop. But in course of time, in that case, it has given an option that either you can come with the putting your mask, maintaining distance to the court physically, or better you can address to the courts by staying at your own chamber. That was for the first time that Orissa High Court adopted, and it has done a very fantastic job till now also. But what happened? Then following to Orissa High Court, many other high courts are also they adopted the virtual court system. I am remembering the Bombay High Court also, the High Court of Allahabad, the bench at Lucknow. I have also appeared. in 2021 and 2022. By staying in Orissa also, I have addressed some of the courts in Lucknow bench of the Allahabad High Court, in Bombay High Court. And also staying at Bombay also, I have addressed to the Honorable Court of Calcutta, of Orissa, of Lucknow, like this. So it has within the activities of the lawyers also. So use of technology is a very good initiative by the justice delivery system. And by using the technology, the number of cases, similar nature of cases are there. How that all can be clubbed.
Yes.
So it is Supreme Court for the first time, many cases of similar nature, which has to be disposed of single by single. It will take a lot of time, both the lawyers and also the honorable judges.
And it may be a burden on the resource as well, because if
Yes,
single.
on the registry also
Yes.
there was heavy burden to trace out. So the registry, what they did, they clubbed almost all similar nature cases. They put it in one item. That item be listed in the court, and at a time, 50 number of 100 number of cases has been disposed of. So that has a very good step by the technology. And recent development of the technology is that because of by using this AI and artificial intelligence and machine learning system, it has again uh, uh, make easy in the system, both for the honorable judges and to the honorable to the lawyers, and also to the registry of the different high court, lower courts, and Supreme Court. And nowadays, what has happened? Almost all papers are becoming digitalized of the past cases. Even some cases which has been disposed of 100 years back, that has become the part of the record in the digital form. So recently, what is happening? Earlier, lawyers were facing difficulties to get a latest judgment of the Supreme Court. They cannot have the resources to enrich their libraries, and it was very difficult task also to having a proper chamber. But nowadays the advantages is that for the lawyers, they can have this digital form of practice even without having book and even files also, because everything has become digitalized. I'm witnessing many advocates friends in Bombay, in Supreme Court of India, here in also in Orissa High Court. Nowadays, they're not carrying the physical files. So the burden of practice was quite high during the then period. But nowadays, the practice has become quite easier and smoother by this using this technology. So what you are telling to me that you have your 5 mobiles and laptop, all these things. I have acquainted myself because I'm a man of 55 years. I am not so techno. I was not so techno savvy. But in course of time, if you have to be in the practice, you have to make yourself little bit of acquaintance with the technologies. That is why I am adopting this technology and I am getting the access by using this virtual court of Bombay, at Lucknow, at the Supreme Court of India, at Calcutta High Court, at Orissa High Court. So that's the recent development of this digitalization of these practice.
Actually, I want to ask you, like, in Facebook or in Instagram, sometimes you will see that what happens is that some reels or some videos of the virtual high court proceedings are getting viral. Like they're
Yes,
being leaked.
yes. One thing has happened. Recent development has happened around 8 months, 10 months back. While the court proceeding at Bangalore is going on, some pictures came out which was not the outcome of that virtual court systems. So amongst the judges, honorable judges of respective high courts, and also the honorable judges of the Supreme Court, they have come to the conclusion that the way we have make it easier, we should have put a
Cap on
restriction to
that.
that. We shall put a cap on that. But what they did, that earlier what was happening, everybody by opening the Google search, uh, they would able to access the honorable high court, and they can open their audio and video was there. They
Okay.
can open the audio and video. So the audio video opening was not under the control of the registry.
Okay.
So that is the reason why these things happened. But when audio video Control will be in the hands of the registry's computer unit, uh,
Mhm.
uh, which is organized, which is managed by one of the manager who is having the expertise on the computer. If the audio video system can be controlled through the registry in a proper manner, anybody cannot access it anywhere in any manner in what form they like. That can be controlled.
Yes.
In Supreme Court, just you see right now, you can access any court. You can view, you can see the proceedings, you can hear it for your own educational purpose, for your own expertise. Almost all the courts of the Supreme Court. But the control of audio and video is with the registry of the
Supreme Court of
Supreme
India.
Court computer section.
Okay.
You cannot open your, if you want to open your own audio also, you cannot open it.
Okay.
To speak, you cannot show your video, even if you want to show your video also.
Hmm.
So what is happening? When the control is remain with the registry, none can play with the virtual system in any different way without the system in any different way. So that control is should be with the registry. So after that Bangalore incident, what has happened through this media, I am advocating. Earlier, we are able to access the High Court of Bombay. Earlier, we are able to access the High Court of Lucknow, Lucknow bench of the Allahabad High Court, Calcutta High Court. Recently, what has happened after that Bangalore incident, you cannot access the court on the website set up by the court. You can access only in the YouTube. But most of the courts has stopped that system. So suppose I have a matter in Bombay High Court. Earlier, what I was doing, entering into the Bombay High Court website, I am getting having the ID, password, and I am giving my case. And it was opened. That was in my hand. But right now, what is happening? You have to have a talk with the court master
Okay.
on the previous date night. That my item is such and such. I am so and so. I may kindly be given the
Access of that.
access to approach to my case. But one problem is that suppose I have a matter at item 10
Hmm.
in Lucknow bench of the Allahabad High Court. I can see in YouTube, in some cases, I can view it in this YouTube that item 8 is going on. But when the audio video I am just opening, I am not getting the access. My audio is completely stopped
Okay.
after that Bangalore incident. So I am requesting, suppose I have a case recently in the Bombay High Court. I cannot, my item was at item 37. I am representing one of the client in Orissa in a national stock exchange matter. Um, till 36, I was not aware of what is going on.
Okay.
So I remain completely alert with my
Proceedings and all.
proceedings entire day. At 4:30, I came to know that it is up to item 35. The court has the court has reached, and thereafter matter has been adjourned. That
Hmm.
means for hearing for this purpose, I remain alert in Orissa for the entire day.
Okay.
So had I been able to access that, all right, item number 34, 35 is going on. I can be a little bit of comfort for myself.
Okay.
But uh, what I request with the justice delivery system across India, that this system to be make very easy,
Hmm.
and the audio video system should be with the registry under their control. That's only I request, so that it can further make easy to the practice and procedure of the court.
Okay. Does these cases, when it comes to YouTube or any social media platform, does it not cause a kind of stress over the judiciary system or the judges, that if we do not do particular thing, if we do not have, if we speak something that is not related to the case, or if we go out of the way to make a judgment on that, that will be criticized by the local public, because it is in the public domain now. If you upload it on the YouTube,
Yeah,
anyone can
yeah,
access it.
yeah. That has it has become a, now the system has become quite transparent.
Yes.
The earlier system was a little bit of sometimes there was heat exchange of words in the course of argument in the court by the lawyers, and sometimes the honorable judges there also react not able to answer to their queries in a proper manner. That's happening, and that will also happen in the YouTube. If that will come to the limelight, that would not have any kind of minus or repercussion, any kind of long-term repercussion on the justice delivery system for disposal of the cases. But when the man is able to access more responsibilities on the part of the lawyers, more responsibilities on the part of the honorable judges, that will come out. Everybody will become serious that their views, their the proceeding has been looked by the general public in the YouTube form. So that has brought by transparency, and I can say that can only enrich the capacity of the both lawyer and the judges, that society is looking to us through YouTube, and we should do a little bit of cautious while we are in the course of the argument between the lawyers and also the queries made by the honorable judges that take place. So everybody becoming little bit of queries. I don't think that this will put any kind of pressure on the honorable judges while they are disposing of the matter while on due discharge of their official duty.
Just tell me how a judge is appointed. Is there is an exam, I guess, National Judicial Appointment Commission, and there is a way to be appointed as a judge when you are when you are working as an advocate for minimum number of years. Then you can be called upon by the bench to become a judge. So I
Ye-
exactly want to know what that method is.
Yes, you see, uh, National Judicial Appointment Commission in 2015, that act came into force.
Yes.
In that, the National Judicial Appointment Commission, uh, apart from the uh, honorable chief justices of the respective high courts, or in the case of the Supreme Court, there are other members were there. Amongst others, Speaker of the Lok Sabha, and nominee of the Prime Minister, and Honorable Law Minister of the Center to be there. In that case, what has happened? Uh, Earlier, it was in-house system. So when National Judicial Appointment Commission came in 2015, this matter has been challenged in the Supreme Court of India. And following to the earlier judges' cases, uh, uh, they Supreme Court of India struck down the National Judicial Appointment Commission, and the earlier that system what was going on, the same system prevailed as such, and that is going on till date also.
So basically, if the
I
Hmm,
may say something that why this National Judicial Appointment Commission, the Supreme Court, why they struck down? Because you see, suppose one advocate who is having his practice in, so to say, in Bangalore, Karnataka bar, about his performance at the bar, how the board members they will come to know, unless it is given, that selection board will come to know, unless it is given it in writing.
hmm,
Only it is given in writing that Mr. X, Mr. Y, Mr. Z, they have their number of cases, they are arguing in so and so cases, and these are their reported judgments, and these are the some of the articles which they have published, and this is their performance in the different years. There are some system. So the performance of a advocate in a high court, that will came to know by the respective judges of the respective high courts. Suppose Chief Justice of Karnataka, he will see, or Chief Justice of Calcutta, he will see the performance of a lawyer is like this: appearance, his arguing, his sovereignty, his impartiality, and above all, the integrity of a lawyer,
hmm.
how he is good enough. These are the things which will come to the knowledge of the respective high court judges first. So on that ground, they feel that no, the earlier system was good. It is only the respective High Court's collegium. They will give their name from the member from the bar and also from the bench.
Okay.
There is a ratio, 30-70 ratio is there. 70% from the bar, 30% from the bench, or 40% from the bench, 60% from the bar, like this. And moreover, nowadays, many female representatives are not there as the advocate of the as the judge of the many high courts and are also
I
uh,
was coming to this because the participation of women in Indian judicial system is too low. If you see, I don't think that in 35 judges in the Supreme Court there is any woman right now.
no, there are presently Supreme Court Madam Justice Agaratna is there,
Okay,
Madam Justice Will is there. So now the representation as from the
it's increasing.
yeah, increased. In different high courts are also they have increased the appointment of lady advocates as a judge of the high court. Recently, I have witnessed 2 years back, uh, Madam Gauri Godse, she appointed as a judge of the high court. Thereafter, I have witnessed Dr. Anil Kedar Gokhale. Uh, she also joined as a judge of the high court. Many judges from different high courts, they have picked and chosen from the age member of the bar. But still, then, in spite of all these things, the representation is very low. Suppose if we'll say Orissa High Court, Orissa High Court at present only one
Female
judge,
judges there.
uh, Madam Savitri Ratha, is the judge of the Orissa High Court right now. So the representation from the women lawyers community is very less, and this is a demand everywhere. The number at the High Court and Supreme Court, it is to be increased. But another development you will mark right now at the lower judiciary, the most of the ladies member of the bar, those are passed out from the 5 years this integrated law college, they are doing very fantastic job, and they have been selected by the judiciary to appoint as the judge of the magistrate of first class. Then many of the representations are also there right now. Just like students, girl students of girl law student, they are doing well. So also they are doing in the selection process. Their number is increasing day by day, and it is a very good sign.
Gradually, they will be like if someone is appointed as a female judge is appointed as a uh, chief justice of a high court, there is a high chance that she can be promoted to Supreme Court in the
Yes,
coming years, and
yes.
we can see in coming years a chief justice, a female chief justice of India, right?
Yes, we can see many female just recently in near future, Madam Justice Nagratna will be the Chief Justice of the Supreme Court of India, and like this, many senior judges are also there in different high courts. Those who can represent to the
Earlier we spoke about there is a ratio of 30 and 70, like 70 from the bar and 30 from the bench. Will this Does this not cause a kind of favoritism, like that particular advocate is a favorite of a particular judge or a group of judges, then he can be appointed as a first class magistrate?
those who are doing well. High Court panel will seek their appointment. After seeing their performance, they will place it before the selection process, and respective state government through the honorable governor, their name will be sent to the Ministry of Law of India, then to the collegium system, collegium Supreme Court. Then Supreme Court collegium will make after verifying all those details their performance, then the intelligence report, then they recommend the
Intelligence report, as in
then they'll give the recommend for appointment as judge of the High Court.
Like intelligence report is also being taken.
Yes, intelligence report is very important.
Okay.
Before appointment, intelligence report is very important for appointment, even in the lower judiciary also. In the lower judiciary also is very, very important, because that will only bring the impartiality, efficiency in the justice delivery.
At last of this part, I would like to ask the process in which how a case is being registered. What are the ways of getting a case registered? Like if you approach police, many times they deny, they don't take your case, and they have to maintain their own records that we have the least crime records or we have the least records in our particular area. So in this case, if someone needs to approach the court directly, what are the ways?
You see, registration of case, different parameters are followed for different cases. For example, suppose you take the case of a uh, stock exchange matter. There is a dispute in between the uh, stock advisor and the player, those who are investing the money in different stocks. Suppose to say Mindtree, Reliance Industries Limited, like this. In that cases, the first initiation of the proceeding, first they will make a application to whom? To the IGRP, Investigation Grievance Redressal Forum is there. After IGRP, anybody satisfied both of the parties, matter is all right. Thereafter, any unsatisfactory party will make an appeal to the, that's called the first appeal system, to whom they will represent and the arbitrator of the stock exchange, national stock exchange, suppose. The arbitrator of the national stock exchange. There are three members body. Anybody dissatisfied on the first appellate forum, they will go to the appellate stage. After appellate stage, they will go to the district forum. After district forum, they will approach to the High Court, thereafter to the Supreme Court. So these are the system. In the, this is a type of case. So to say, civil case. In civil cases, how they will approach? First, they will file their cases. Plenty will file the case in the city civil court or in civil judge junior division. Thereafter, any party dissatisfied, they will approach to the civil judge senior division. Against the order of the civil judge senior division, any party aggrieved, they can approach to the Honorable High Court of Odisha.
Okay.
Sorry, Honorable
And
High Courts, different High Courts. So this is a process. This called the, whether original jurisdiction or appellate jurisdiction. This is called the appellate jurisdiction of the High Court. Are you getting point?
yes.
Appellate jurisdiction and original jurisdiction. This is the, these are two instances what I give the appellate jurisdiction. Suppose in a criminal case, something happened, you file a FIR, FIR not being registered, you rush to the criminal court, file a complaint case. On the complaint case, law and magistrate issue a 202 inquiry to the police. Police inquire into and submit to the court, yes, this is a case. Then law and magistrate will take the cognizance, then issue the notice for appearance of the parties. This is the system in criminal cases.
Okay.
Right? But when the one of the party not satisfied with the proceedings of the first uh, uh, criminal court, they will make appeal to the sessions court. Then after sessions court, they will appeal to the Supreme Court in different forms, like criminal appeal, like this. So in this is called the appellate jurisdiction. Original jurisdiction what? Suppose there is a matter, something happened, enter in a area, there is electricity cut about for months together. In that cases, many aggrieved peoples are there, consumers are there. They will immediately go to the High Court and file, sir, you see, we are the consumers, we have been deprived of this electricity or we are deprived of these facilities, and there should be writ in the nature of mandamus. You direct to the department, they should restore the electricity for a normal functioning. So that's called the original jurisdiction. The honorable court can show moto. That's the original jurisdiction. So moto they can exercise the power and can impose different kind of writs are there. Writ of mandamus, writ of coherent, writ of certiorari, writ of habeas corpus. These are the different 5 kind of writs are there.
Yes.
So the nature of writ require honorable court accordingly they direct that is by exercising original jurisdiction. That is under Article 226 of the Constitution of India. The jurisdiction of the Honorable High Court that has been empowered by under Article 2. The same also Supreme Court can exercise under Article 32 of the Constitution of India. They can so much exercise the power and issue the either writ of mandamus or current association as for the prayer made by the respective advocates. But recent development in the system from which has Government of India, they have uh, adopted this Bharatiya Nyaya Sanhita, Bharatiya Sakhya Sanhita, then Bharatiya Nagarikya Suraksha Sanhita, BNSS, Bharatiya Sakhya Sanhita, BSS, and Bharatiya Nyaya Sanhita, BNS. In this process, suppose anybody want to file a criminal case, something has happened, he can file the FIR at any case in the either short form or by the hard copy. Nowadays, they have make the system very transparent. And suppose the respective, suppose one offense committed at Gujarat and the cause of the man is from Gujarat, the offense happened at Orissa. So the complainant, he would be in a better bargaining position to file his case at which jurisdiction he want to file it. So the new development of laws that all this criminal law amendment, it is a very innovative step of the Government of India. They have done in a very transparent manner, and they have give emphasis more on this technology. Suppose in some cases notices has been issued, but the opposite parties are not appearing. In this case, what is happening? You can issue the notice on e-form. By giving the mail also, you can send the notice. And because you can able to know that whether your mail has been opened or not, you can able to get all those details by through the court process.
Yes.
So that has become more transparent and more easy way of
Registering your
clients,
cases.
yes, the clients access to the courts.
What I can see that Indian judiciary is adopting technology in gradual manner. But
Yeah.
what it needs is that we need to pace it up so that we can clear the pendency of the cases that we currently
Yes,
have.
yes. For that reason, there is lot of training program for the practitioners. Those who are practicing at the lower judiciary, then district judiciary, high court, and also in the case, some cases also in the Supreme Court. Training program for the advocates, how they can access the court proceeding, how they can file the cases through uh, mail, through internet, and how can even they give the court fees instead of paying the court fees directly in the form of physically. How can you file the submit the court fees through your using the internet and digitalization formula that has become quite smoothen nowadays. And in each high court, there is a office, those who are dealing with this part for filing and listing, for mentioning. Even you can do the mention by staying in your own house. You can submit the mention memo to the different honorable high courts, a different jurisdiction. And honorable high court, they can get the number and they can address in the first sitting. Yes, your serial number in so and so. What do you want to say? Then the respective advocates or the clients, sometimes they mention the matter that this is my urgency. This matter may kindly be taken up in a priority basis. So this kind of mentioning, appearance, argument, written out of argument, all these things can do through this by using the adopting the technology.